Thank you, Mr. President. I also intend to vote no on Senate Bill 229 and rise to explain my no vote. About a month ago, I met a resident named Michal. She's around my age, happily married with 2 wonderful daughters. I look at them and I see exactly what I would hope for in a vibrant, loving family. Exactly the type of family I'd hope to have myself. But without access to a D&E abortion that allowed them to terminate their first pregnancy, this family may never have been. Michal reached out to me to share her story, and I rise today to share it with you. 1 year after they were married, Michal and Jordan found out they were pregnant, and they were overjoyed. Throughout their pregnancy, Michal felt wonderful, as healthy as could be. All of the regularly scheduled checkups in the early stages of her pregnancy showed everything was on track. They were excited about starting a family and the opportunity to bring someone new into the world and share all of the love and joy that they had to share. When they got to their 20-week appointment, they had no reason to expect anything different. Heartbreakingly, her doctor came back in a somber manner. The diagnosis was severe osteogenesis imperfecta, a form of skeletal dysplasia caused by defective genes, which prohibited the fetus from producing collagen. The bones simply weren't developing. After discussing the severity with their doctor, Michal and Jordan learned that if their baby survived being carried to term, it would likely live a very short life suffering in great pain. The diagnosis was so severe that a sneeze could break a rib. Their doctor advised that they should consider terminating the pregnancy. Michal tells me that even discussing her story with her friends, many say they could never consider abortion an option. Michal says that neither could she until she was faced with the situation head-on. Until she was faced with the idea that she would be bringing someone into the world who would do nothing but suffer if they made it through the pregnancy at all. Her husband, Jordan, didn't realize they were suddenly in a category of abortion. To him, he said they needed medical care. He thought that given their situation, the system would help them get the care that they needed. But getting that care wasn't easy. Despite living in Oakland County and having access to some of the best hospitals and medical professionals in the state, Beaumont couldn't perform the procedure. Despite making the difficult decision to terminate the pregnancy with the counsel of their doctor and together as a family, Jordan says the team there suddenly became very nervous and made it difficult to schedule an appointment. In the midst of the most emotionally challenging time of their lives, they had to go on the michigan.gov website and fill out a government form acknowledging the procedure that they were seeking. They felt exposed, vulnerable, and angry that the system suddenly seemed to work against them, not for them in their time of need. Michal and Jordan had family connections in medicine and were eventually connected with the maternal female medical specialist at U of M's Women's Hospital. The hospital was incredibly careful with how they chose to proceed, running further tests, spending time discussing all of the options, the harsh reality, and the challenges with Michal and Jordan. The hospital independently verified the recommendation of the first doctor that due to the severity of the case, terminating the pregnancy now would save the fetus from tremendous pain and suffering and would also protect Michal from future complications. After the procedure, which the hospital meticulously performed over 2 days, Michal and Jordan spoke with their doctor. "I know you don't need any more information that you made the right choice," the doctor said to them, "but the situation was worse than what we were able to see in the ultrasound." The doctor informed them that there were skull fractures and that the situation would have only gotten more dangerous and complicated as time went on. This D&E procedure was the safest option, conducted by a top team of professionals for Michal and Jordan. According to U of M, it has become the standard treatment of care for terminations performed after such complications arise, just like the situation for Michal and Jordan. Michal's D&E procedure took place in November. The following August, she was pregnant. Zoe will be turning 3 at the end of this month. Lior, her second daughter, was born 18 months later. In Hebrew, her name means my light, which Michal and Jordan chose because she was born on the last night of Hanukkah. Michal shared her story with me, a story not dissimilar to many other women and families facing this decision, because without access to the care that she needed, she would not have the wonderful family and 2 healthy daughters she has now. Had she not had access to this D&E procedure, Michal's situation would likely have gotten much worse and would have resulted in her own life being in danger, or complications that may have resulted in the inability for her to ever conceive again. I know how passionately people feel about this issue. I know that everyone here believes they are doing what is right to protect families. But without this procedure, the safest procedure possible when complications like this arise, Michal and Jordan's happy, healthy, wonderful family would not exist. I urge a no vote on SB 229 and SB 230 for the protection of families. And I request that my remarks be printed in the journal.